Hey, everybody. Welcome to episode 293 of the Immigration Lawyers Podcast. Wow, we're really hitting up there, but hopefully get to episode 1000 soon. I want to thank all the toolboxers for listening. We got a lot of good info coming up. This particular episode is about the Ombudsman's 2023 report. Got some interesting stuff in there. There's always some good statistics and little pieces of information that could be learned to be helpful for your practice. The Ombudsman's office was at the ALA conference. There seemed like very nice people there that want to be helpful. But it's really good to just check out this report if we can. The PDF is available on their website. They work really hard on creating it, and then again, there's a lot of pieces of statistics in there that's helpful, a lot of nuances, information, and I read through it, and it's not like a thorough go through of the whole thing. I'm going to do it just little points here and there that I picked up. And if you're watching the video version on YouTube, I'm going to be screen sharing as I'm going through it, so that might be a fun thing to do. Before we start, I want to hopefully get this video out in time. I have a meeting, a conference I'm doing, a roundtable, let's say, with Ruby Power. She wrote the book for ALA about practice management. It's a deep dive roundtable called Exploring Law Practice Management Hot Topics from the ALA conference, July 26th at 12 p.m. Central Time. If you're interested in that, email me. I'll send you a registration link. But we're going to talk a lot about business management stuff. Should be a lot of fun, a lot of interesting stuff. Ruby's great. She's going to be on the show. I read the episode before this is when we post hers, but she's probably going to be a regular. We're going to do a lot of stuff together. It should be a lot of fun. If you're interested in learning about marriage-based immigration, consular processing, adjustment of status, to run the kind of firm operation that I have a course for it. And just email me. I'm redoing the whole thing, so it's gonna be a fresh look to it. info@immigrationlawyerstoolbox.com. Sign up for the course. You may be an attorney who's trying to become an immigration attorney or new in the immigration field. You may have even done marriage cases before, but you want to learn the way I do it, and a lot with actual statute and regulations and stuff like that too, and be part of the community. It's really, really helpful. And speaking of being part of the community, I just released an episode where we talked with Marina Shapelsky, who's in New York, about her background, but we also did a separate recording about marketing on and how to do on TikTok, how she does that. She create a really strong firm based on TikTok marketing. It's a half an hour session that's available for free for immigration lawyers on our community page on circle.s. So if you're not a member already, message me info@immigrationlawyerstoolbox.com and we'll add you to circle.so so you get access to the ongoing onslaught of massive amounts of practice information and guidance that we're putting there. We can also ask questions too and get answers hopefully. So that'd be really cool. Speak of all the information we provide, the magazines out, Immigration Lawyers Toolbox Trade Magazine, issue number 7. I want to thank our sponsors in the magazine as well, DocuWise.com, the all-in-one form software and management system, case operations. It's an all-in-one package, really helpful kind of stuff. You can do a practice session with them and even play around with it to see how it is. If you want to make the switch or go from a monthly plan to a yearly plan, it's something to look into. It's DocuWise.com. They're really helpful over there. Been a sponsor of the program for many years now, so really appreciate them. Now, what we're going to talk about right now is not intended for individual legal guidance. It's general information only. And if you've been listening and you like the stuff we're talking about, please leave a 5-star review wherever you're listening to these podcasts. It helps us get the word out by having these kind of reviews and stuff like that. So I appreciate it. So I just turned on sharing the screen. I read over it once and I made notes on my app that I have. What is this thing called? What am I looking at? It's Remarkable. It's not an app. It's this tablet I use. Nathan Heights put me onto it. So it's pretty good. I mean, take a side context kind of thing. So I don't like reading stuff on the computer. I like having like a book kind of thing. And with this annual report, I just realized I could take the PDF of it, take it to Remarkable, which is this like it's like an iPad, but it's black and white, and it's for reading and writing. And so I put it on there, and then I can read like a book and make notes on it. So it was really helpful because I just don't like reading long PDFs or books and stuff on a computer. So this is a good switch. It's gonna be really helpful for my reading purposes. But okay, so the annual report 2023 Citizenship Immigration Service Ombudsman, published July 30th, 2023. Note that the Ombudsman's not a part of USCIS. They make a big deal of that. They're not USCIS, so they're making a big deal about that at the conference so people get confused. They're really kind. They do this annual report where they publish their thoughts on it. And I got some notes. So it starts off with the 2023 Acting Ombudsman's message. They say, as a small office of fewer than 50 federal employees, the agency, USCIS, dwarfs us in its resourcefulness and knowledge of its own issues, Both their vantage point in particular our ability to engage with a diverse range of stakeholders enables us to shed light on those challenges with a unique voice. Although we do not always agree, we deeply appreciate the ear lent to us by Director Jadu of USIS leadership and USIS workforce at all levels. So one, I was just highlighting this part because there's not that many people working there, so they're really overwhelmed probably. And it's interesting in the opening message, he said, although we do not always agree. It's like, why would you have that line in there? But just say we appreciate it. So it shows I think they see the angle the perspective that we see when we have clients, and just some of the madness sometimes when you're dealing with the agency and the form and stuff like that. They see the frustration people have. So I just highlighted that was interesting to put that in there. And it says USCIS not only took action the next month by changing. Okay, so one thing that they did, and we'll talk about this again later, is one of the main changes is for getting the ADIT or added stamp. When your green card is expiring, you need evidence of it, and the extension paperwork that you guys expired too. If you're doing like a I-751 or I-90 or something like that, the ombudsman helped, and they got it where instead of going in person to get an ADIT stamp, now they're sending like a piece of paper that's like an I-94, and that covers you, so you don't have to go in person anymore, which is a big time saver and just messes the whole InfoPass system. Another note here says, while Congress has appropriated money to help the agency address some of its most significant humanitarian workloads, the agency still operates on fees no longer adequate to fully cover the magnitude of the work. So, the increase in asylum cases and humanitarian stuff, the mass amounts of funds that are happening, all the parole stuff they're doing, the U4U for Ukraine, this puts a lot of strain on the agency. And so we got to give it to them that like the fees. I mean, I've been paying $535 for I-130 since I started. There's been inflation, so these things got to go up. So they keep getting sued on these price increases, and people challenge it, but these fees have to increase. It just doesn't make sense. Now, when they do increase, the service level has to increase too. So that kind of goes with it. If it doesn't, that's a problem. But I understand like the financial perspective. They say we were able to move further into the age of social media, expanding our reach through Twitter as well as Facebook. We expanded our use of videos in both English and Spanish to reach a more visual audience. So just note that you could try to like follow them on Twitter and Facebook. And sometimes if you have issues and things aren't going anywhere, even when you contact the Ombudsman's office, their website, you can leave a comment there or make a note or a direct message. Maybe that'll be a back channel way of getting to someone within this organization. It sometimes works. Sometimes if it's U.S. Embassy, you tweet them and say, hey, this doesn't make sense. And it doesn't always work, but it's possible that may work to help. Next thing is they say, temporarily increasing the maximum limit on individual daily credit cards. So yeah, one thing that was happening, I think it was for H-1Bs, that there was a credit card limit of like $40,000, and some of these companies do so many H-1Bs. I mean, $10 a piece, we're do 80,000 one. Then that doesn't make sense. There's $10 for H-1B registration, and you put one credit card at $10 a piece. Let's do the math. You spend 40,000. Okay, it's public math. So 40,000 divided by 10 is 4,000. Okay, 4,000 H-1Bs. I guess the big companies do it. But I did my math backwards. Let's say 80,000 or something. But they're able to fix this maxing out credit card issue and to address delays in adjudication of derivatives of employment-based adjustment status. Okay, so they were able to fix that. I think they even fixed it where like the client didn't have to do anything. The applicant, they were able to internally fix it. So that was interesting. I want to note that credit card issue. And to addressing delayed adjudication of derivatives of employment-based adjustment status for applicants and problems related to aging of the applicant. So they fix that kind of stuff up. So it just talks about several of the stuff that they worked on. Now, here's a note that says it also has a chief resource, probably 20,000 employees that are steeped in central mission of the agency. So there's a lot of employees. I think it's USCIS that they have. Sorry, I'm jumping around a lot, but this is just like random pages. I just like highlighted. So this is interesting to put it in. And note that we have the acting ombudsman right now, Nathaniel Stiefel. Previously, it was Phyllis Coven who was working on this stuff, and it's a lot of hard work getting this report out and the rest of the stuff they do. Okay, so executive summary. They go through 4 or 5 different particular things that they spotted that are troublesome, and we're not going to touch on all of them. The first was the growth of humanitarian mission of USCIS and its impact on future workloads. The second one was the use of requests for additional evidence on L1 petitions, which was kind of unexpected that they've gone to L1s all of a sudden. But I stopped doing L1s a couple of years ago because the RFEs were so out of control and so obnoxious and time consuming that it wasn't, worth the time as a business for me to take on these cases. They make notes on this, and I'm really optimistic what they said for me. But since I've getting back into doing L1s again, they say stakeholders continue to report difficulties related to USCIS's issuance of requests for evidence, a topic first studied by the CIS Ombudsman in 2020. This time, we are specifically looking at RFEs issued for extension petitions of the L1A and the L1B non-immigrant categories based on stakeholder reports of overly broad and burdensome RFEs, duplicative RFEs, and inconsistent adjudications, lack of deference to previous decisions, and a misunderstanding of the standard of proof. And we're going to go into that a lot. That was very interesting what I wrote there. It's very helpful. They also talk about temporary protected status, the impact charges of increased demand. I look back at USCIS's unprecedented fiscal year 2022 efforts to use all of the employment-based visa categories. And they make note here, and they talk about exploring the immediate digitization of Form I-693, report of immigration, medical examination, and vaccination record. And in the meantime, the agency should consider establishing a central location for the receipt of new or uploaded medical examinations, like a centralized process created for transfers of an underlying basis in FY 2022. So the I-693 is really important for me because this is in marriage cases in particular. I have this issue a lot where the doctors constantly make errors. So if it is a digital form that forces them to fill out boxes correctly, this would be great, because about 10 or 15% of the time I have to fight with these doctors to correct their I-693s that were incorrectly made. So that would be, I'm glad they mentioned that one. That was very interesting. All right, so let me fast forward. So this was one going into the humanitarian programs of USCIS. Here it says some of these applications and petitions have historically been given a lesser priority for a variety of reasons. These include a lack of sufficient staff to address them, and in some cases for lengthy timeframes. Many of those who are not given high priority are chosen because it is logical to do so based upon time sensitivities. For example, and this is where the points come in, those who have filed I-751 petition to remove conditions on residence are filing to remove the condition status lawful permanent residence. They must maintain lawful permanent status. I'm not sure what's going on. Blah, blah, blah. So they're delaying I-751 because they have status. I-130s that don't have like immediate next step consular processing available to them, they're delayed. So it's like they intentionally do this stuff. Sometimes some petitions taking longer because it doesn't affect the applicant in their perspective. Now for the I-130, sometimes I see F4 petitions, siblings of U.S. citizen I-130s be approved in like a year and a half. And I'm like, dude, I have a married case. I have a child U.S. citizen spending 12 months and you're spending your time on F4. So F4 really should take as long as possible because it helps with the Child Status Protection Act as well. But that's a thing right there. There's a note here on, let's see, page 4 of the report. It says, for instance, petitioners with pending I-751s have no ability to file for naturalization or even move on with their lives. I think that part was an error. You can file for citizenship if you have an I-751 pending. We do that regularly as a general policy office. We do it in almost all cases, but that's something that's there. And then they reference petitioners with a pending I-730 cannot reunite with their loved ones. Yeah, the delays are really messed up. I-730. Petitioners who file I-601 to proceed on immigrant visas cannot move forward on their permanent resident status. That's another one that's taking like many years right now to get an I-601 approved, that's out of control. But many other types of forms continue to show a distinct lack of process in reducing lengthy processing times. The median processing time for I-130 was 13.6 months. I-751s were 19.5 months. And the average processing times for I-601A was 34.3 months. That's crazy. 34.3 for I-601A. That's wild. And I didn't mention I-129Fs here, and it's not on the chart they have here. And I-129F fiancé petitions are taking 15 or 16 months. It's even worse than the I-130s. So that's a thing that's troublesome. Now they do reference the USCIS processing goal timelines for October 2023, which they released like a year and a half ago, where they said we're going to get like I-130s and all this F1, everything done in 6 months essentially, and that hasn't happened at all. And even the I-131 advanced parole, they were saying get done in 3 months. That's not happening. So I-24 in 3 months. I had one case I-24 approved in 3 months, but almost all of them are taking 12 plus months. They should just get rid of the I-24 when it comes to certain types of cases. The next page, they say these efforts continue to 2023 with the development of an opening of the Humanitarian Adjustment Removing Conditions of Travel Documents HART Service Center, the 6th service center, the first to focus exclusively on humanitarian and similar workload cases. The first service center not fully tied to a physical location, and for which the plan is for a fully virtual center. The HART or Heart Service Center is expected to focus on certain humanitarian benefits. It's also expected to have dedicated workforce, ensuring the application under its portfolio are less likely to fall behind other priorities. So it was an interesting thing of them opening up this 6th service center that's going to be virtual, focus on these kind of humanitarian cases with child documents. And then finally, the agency continued to address symptoms of the continued backlog. The most obvious of these include a temporary final rule promulgated in May 2020 and valid until October 23, which adjusted EAD receipt validity for many applicants from 180 days to 240 days to 540 days. The reason why I mentioned this part of it is that this automatic extension of 540 days for EADs is set to expire on October 2023. So you won't be getting these kind of extensions. So be mindful for that. If they don't extend it further, this is something that you gotta, mention to your clients and be prepared for when you get these work permit extensions or inability to get the extension. Now, a quick note here on the Ukrainian program. It says the U4U program. The program ensured that approximately 116,000 Ukrainians were granted parole through the program in 2022, with an additional 22,500 being granted parole at the border before the program was initiated. So that quickly, 140,000 people were allowed into the United States. That's a massive number, and it just was interesting that they were able to, on a dime, flip a switch and do that. Prioritizing the growing caseload. In calendar year 2022, the CIS Ombudsman once again received a record number of requests for case assistance. We received 27,137 new requests for assistance. This constituted a 4% increase from 2021 and an 86% increase from 2020. So that's a lot of work. It almost doubled in the last 2 years. All right. So they say, for example, we provided to USCIS in August 2022 an informal recommendation on expanding the use of receipts for I-90 applicants and issuing aided stamps by mail, both of which USCIS implemented shortly thereafter. So that was good. We also issued 2 formal recommendations to USCIS during fiscal year 2022. The first, issued in March 2022, referenced the need for non-immigrant work beneficiaries, in particular H-2A, H-2B beneficiaries, to receive notifications of the outcomes of petitions in which they are named beneficiaries. USCIS's response to this recommendation voices concern regarding the notice, especially with regard to the standing of any beneficiary with respect to a petition which is filed not by the non-immigrant employee but by the employer, although it acts as a change of extension of status for the employer as well. So this is really troublesome because, again, these kind of visa categories, the H's put a lot of power on the employee and can lead to abuse, especially when you're looking at H-2A and H-2B categories. So we really want them to have their paperwork and not have it dangled in front of him or held in front of him. This is one of those troubling things that I would love for them to do. One is to create standing that this is appropriate, but also just give the people some receipts. They go on to say Congress has, however, had the last word in fiscal year 2023 appropriation legislation for DHS. USCIS was ordered to establish a process whereby workers may confirm that they are the beneficiaries of H-2A or H-2B petitions and can receive information about their own immigration status, including the authorized period of stay and the status of any requested visa extensions. They're I-94s. Yeah, well, they should get the I-94s. That's just is common sense, but sometimes it takes a while for that common sense to kick in. So that was the first part. The next thing is the growth of humanitarian mission of USCIS and its impact on future workloads. And these programs they have where they just let 100,000 plus Ukrainians in immediately. It's all under the parole power section 212D5A of the INA Immigration Nationality Act. So I wanted to reference knowing these sections, and I'm really big on knowing statutes. It's really important. As I'm recording this, they just announced that they're going to let people from Guatemala, Nicaragua, Colombia, Honduras, or something like that paroled in if they have an approved I-132 to hang out here and get work authorization. So this power that they have under 212D5A is extraordinary. And they're probably going to be using it more and more because the courts seem like open to it. So I just wanted to mention that. It says granting parole is a discretionary decision. USCIS and other DHS components are not required to grant humanitarian parole to any person based on predetermined criteria. Instead, is granted on a case-by-case basis, requiring DHS to evaluate each applicant individually. In essence, immigration parole is official permission for non-citizens without another status to enter and temporarily remain in the United States. It is a discretionary protection similar to the concepts of TPS and DED. Eligible individuals in these populations can work and remain in the U.S. for a prescribed period of time. because of safety concerns. And unlike in other urgent circumstances in the country of origin, unlike TPS or DED, parole is generally granted to individuals outside the United States. Parole is not a method for circumventing normal visa issuing procedures or other immigration pathways like refugee resettlement process. Under U.S. immigration law, being allowed to enter the U.S. under parole is not the same as being admitted into the country. So remember that. So moreover, the grant of parole does not confer any particular any immigration benefits on its own, as commonly parolees do not receive the resettlement assistance given to refugees. However, parolees are eligible to apply for employment authorization, file for asylum, or if available, request to be re-paroled in. So that's just an important note for the difference in admission and parole as well. If you're going to do an INA 245 adjustment, for example, and using the subsection 245K for employment-based cases, EB 1 through 4, I think EB 5 is included in that, according to new legislation. I don't want to get too much to 245K, but 245K doesn't apply to parolees, only applies to admittees. So just be mindful of that nuance. Humanitarian parole programs are designed to consider immigration parole for entire groups of individuals based on preset criteria. In these cases, individuals outside the United States, DHS discretion to allow them for urgent humanitarian reasons or significant public benefit. And the reason why I want to mention that is I always go for the humanitarian reason, but you can always go around and do the significant public benefit aspect of it as well. That's something to get into and talk about. Congress did not define urgent humanitarian reasons, all this kind of stuff. Although there are currently no statutory or regulatory definitions for these terms, they may have taken on particular meanings, as stated in DHS's parole MOA. DHS has generally construed urgent humanitarian reasons as urgent medical, family, or related needs and significant public benefit as limited to situations that may benefit the larger community, such as participation in legal proceedings. However, as practice has evolved in response to specific circumstances or humanitarian considerations, DHS has developed a speed, especially humanitarian parole programs for various class individuals. And here's some history. An earlier humanitarian parole program comparable to the most recent use of parole authority is the one created after the fall of the South Vietnamese government in 1975 and the withdrawal of U.S. troops from mainland Southeast Asia. This program, known as the Indo-Chinese Refugee Program, allowed an unlimited number of non-citizens from the region, either individually or as members of a group, to enter the U.S. without visas under the Attorney General's discretionary parole authority. More than 140,000 non-citizens from that region were evacuated and processed from reception centers into U.S. communities. In response to this crisis, the U.S. government enacted the Indochina Migration and Refugee Assistance Act, enabling $455 million for a 2-year evacuation settlement program. That was the 1960s money or 70s money. It's probably like like $2 billion. The Adjustment of Status of Indochina Refugee Status Act was enacted to enable the creation of a record for admission for permanent residence for eligible individuals. Accordingly, the act authorized refugees who are paroled into the United States from mainland. So over the next 2 decades, more than 3 million people fled Vietnam, Laos, and Cambodia, with more than 1 million resettling in the United States. So it's just interesting little history of how these things happen. Another one I would mention, because you'll hear about this CAM program. Another similar program is the Central American Minors Program, CAM or CAM, refugee program established by the US CIS and DOS in 2014. Similar to CHNV, I think that's the Indochina one, I'm not sure. Parole programs had been expanded to encourage individuals to seek orderly and lawful pathways to migration. During that period, USCIS received 10,500 applications and admitted 3,000 plus individuals as refugees on this program. For example, OAW, I think OAW is the Afghan program, became multi-agency effort in which the parole authority was the most effective tool to quickly allow en masse entry of Afghan nationals into the U.S. for temporary protection. The U.S. government also launched a sponsor circle program through which small groups of U.S. residents collectively committed to facilitate integration efforts for Afghan individuals. Under OAW, Afghan nationals were paroled into the United States for a period of up to 2 years. And then increasing workloads. One note is we learned from stakeholders, they say, that a number of Ukrainian parolees have experienced delays after filing for I-765 in receiving their initial EAD. Additionally, as of February 2023, more than 116,000 Ukrainian nationals who have been granted parole under the U4U program are also eligible to apply for EADs. And then there's a chart that shows between Cuba, Haiti, Nicaragua, Venezuela, United for Ukraine, Operation Allies Welcome. It's like 200,000 plus, or maybe even 250,000 plus people are paroled here. The reason why I mentioned this, in particular U4U program, is that the number of these people coming here are going to increase other options later on. For example, when they marry U.S. citizens, want to adjust status, it just increases the opportunity for as a business side to be able to reach out to these communities. In particular, U4U, I think highlighted for my own purposes. My associate attorney is Eastern European and Russian speaking. So this, all these people here have different avenues that they could apply for benefits. So having marketing really focus on this group is going to create a lot of opportunity because there's a lot of people there coming. So for business wise, it's something to look into. I get a lot of people from Afghanistan. Afghans contact me because I'm a Farsi speaker. I don't handle the special parole cases or the issues that they deal with, so I can't really help. But if it's a community where you have a language connection as well, it's something that I recommend looking into and for business purposes. And then they say in the most recent proposed fee rule, the agency noted that its costs have increased considerably due in part to expanding humanitarian casework and accordingly must increase filing fees for employment-based immigration applications to offset the cost for its humanitarian workload. That's not fair. USCIS has been open and on how it can open about how it cannot maintain adequate service levels with its current levels of workload. Blah blah blah. So that's off. I didn't like that because it's not fair to put on the employment people. It's already expensive as it is for these employers to do this kind of stuff. All right, let's go. USCIS request for additional evidence and L1 petitions. They say while H-1B RFE rate has fallen to 9.6%, L1 filings are issued RFEs nearly 4 times as often. And the CIS Ombudsman make the following 5 recommendations USCIS. 1, develop and provide training that ensures adjudicators understand how to apply the legal standard of preponderance of the evidence typically presented in each type of case. 2, develop and provide annual training to ensure adjudicators know how to comply with applicable regulations for L1 extension cases. 3, streamline the L1 extension petition process when the case involves the same facts, specifically the same petitioner beneficiary job. 4, update RFE templates and systems to ensure the RFEs are precise, easily understandable, and do not contain excessive verbiage. Yes, please. 5, establish a robust quality assurance program for RFE. So that's really important because that really is a major issue that we have to deal with the agency on these RFEs. So this is what I want to talk about, preponderance of evidence legal standard. When evaluating submitted evidence, USCIS generally uses the preponderance of evidence legal standard for review. USCIS adjudications examine each piece of evidence to determine whether it is relevant, probative, and credible, and sufficient, both individually and together with the other evidence, to determine if the fact is more likely than not true or probably not. Importantly, the preponderance of the evidence legal standard does not demand that the benefit requester convince a reviewing adjudicator that the submission should be approved or to distinguish all doubt about a given fact or conclusion is true. Rather, when probative and credible evidence is advanced that tends to make a fact more likely than not true, it's really 50%, more or less 50+% or something like that. The preponderance of evidence legal standard teaches that fact has been established even if incontrovertible evidence is absent. So this is really important. And in particular, in an effort to streamline my cover letters, I don't include information about this legal standard. However, I've seen files filed by their attorneys where they spend like half a page to a page talking about the legal standard, and when they do the RFE response or notice of intent to deny response, they reiterate the legal standard for USCIS to know. And I was, I guess, mistakenly under assumption that I'm like, they already know. So for me to go back and say oh, you're missing the standard, all this kind of stuff, it could be a weird thing, and it takes up more space. I like making sure it's succinct. So I stopped doing that, but I didn't do it. But now I'm going to make sure to include this language as a reminder at the beginning in a separate section, like a one-pager, and remember the standard, legal standard, remember the legal standard, because they could come off with clear and convincing standard or some crazy standard when it's not the case and it's not the way they should be looking at this kind of stuff. So I definitely wanted to bring that up because that's an issue that we deal with on these kind of cases. Now I'm trying to change the page when I'm watching it, but the option, the function to change the page is missing. Oh, here it is. It went off the page on the side. So that's something I wanted to share and probably do in all your cases, the preponderance of evidence standard. Just reiterate it that this is not every 99% of USCIS stuff is preponderant evidence, but there's certain things here and there that increase the standard. For example, if you get married in removal proceedings, or you get married, you get your green card based on marriage, you get divorced, you turn around and marry someone else, like that could be another one. If you are doing an EB-1A and you want to continue working in the United States after you come, you have to show that clear and convincing standards, like these random things that are there. But just want to mention that. It goes on, if an adjudicator is inclined to deviate from previous approval, they must must articulate the reason for not deferring to the previous determination, unquote. The policy manual further states that deviation from a previous application approval carries important consequences and implicates predictability and consistency concerns, so much so that the deference policy requires adjudicators to obtain supervisory approval before deviating from prior approval in their final decision. So that's in the policy, it seems. The USCIS quote offers officers consider but do not defer to previous eligibility determinations on petitions or applications made by CBP or DOS officers making determinations on petition filed with USCIS corroborating evidence on a record as previously provided by DOF. So one note is, Trump made it so that there was no deference. That came back, so they're supposed to. There's this nuance, whereas if you did an L1 through the embassies, a blanket L1s, or you did it through like CBP port, like with Canada, that USCIS could review it. But here it says, this exception disallowing giving deference to extensions that were previously adjudicated by CBP officers implementing authorities granted to them by the United States, Mexico, Canada, USMCA, or NAFTA, and to individual entering on L1 blanket petitions whose visas are adjudicated by DOS consular officers pursuant to a regulatory provision authorizing them to adjudicate to an individual beneficiary. That just explains what I just explained. Okay, so that was that. So note that, yeah, you might not get the deference for those particular kind of cases, but they're trying to say, hey, if the L1 is already approved, you got to do it. Now, what if you have an L1 new office 1 year and you get an extension? That's a little bit different than if you had initial like L1. That was not a new office extension, but those things to be mindful of. Stakeholder concerns. Consistent with our 2020 RFE study, stakeholders continue to identify difficulties with USCIS RFEs. In summary, stakeholders claim RFEs issued by the agency are redundant, boilerplate, burdensome. There's explanation of all these are, but just, it says it all. And so inaccurate, inadequate, so all these issues exist. USCIS L1 RFE performance data 2017-2023. They have a chart here that says, according to publicly posted performance data reporting composite L1A, L1B RFE data shown below from fiscal year 2016 to first quarter of 2023, USCIS issued RFEs in 45.7% of completed cases, including those requesting a petition extension. That's crazy. That's a high RFE rate. In FY 2022, when USCIS policy explicitly barred its adjudicators from according deference to prior USCIS adjudications involving the same petitioner, beneficiary only facts, 54.4% of completions had an RFE, meaning that RFE was issued more than half of all L1 petitions completed. And so you can tell your clients, you just expect an RFE. In fiscal year 2021, the RFE rate remained high, with the agency still issuing RFEs slightly more than half, 52.3% of completed cases. USCIS reinstated its deference policy midway through fiscal year 2021. Fiscal year 2022 data shows a marked drop in L1 RFE rates, down from 52% to 36%, which we believe is reflective of a full year of adjudication under the completed under the new rule, under the new agency reinstated deference policy. So that's really important because it kind of goes in line the frustration with the L1s. I mean, half of them get RFEs. I mean, you just got to bake that into the cake that you're going to get a nonsense response. But it seems like they're bringing it down. I mean, now it's a third, but third is still a lot. Then again, I see a lot of like bad L1 cases too. Now, the Ombudsman's office went and took a sample of these cases, and this podcast is running long. I have to go through some of their stuff. I wasn't expecting to go this long. I might have to like fast forward some stuff. But okay, let's get back into it. Based on this limited sampling, we assessed that the 21, so we did 40 sample of cases. That 21 of the 41 L1A, L1B files reviewed involved the issuance of questionable RFEs. More than half of the RFEs the Ombudsman was saying were questionable. So that's annoying. That's just annoying. We also found it noteworthy that some adjudicators appear to highlight certain words or passages in a given support document, presumably as an aid to assist them as they adjudicate the submission. But in most of these cases, neither petitioner statements nor supporting documents were annotated. Oh, really? Additionally, we found that one of the files contained a checklist, but USCIS advised that this may have been produced by the adjudicator and is not an official standardized checklist. That's not good at all. Lastly, USCIS advised that it does not have a specific protocol requiring or prohibiting adjudicators from making notes and or adding them to the official record of proceedings, but if notes are made on the documents or inserted into the file, they would not be removed. And that's kind of weird. What we found, and this is horrible. Ombudsman says, what we found was that during the initial adjudicators training, basic at the USCIS Training Academy, only 2 hours of 5 weeks program appeared to directly address the preponderance of the evidence legal standard. So that goes to the preponderance legal standard. It should, 2 hours for that is not too bad. But in addition, in a 16-page training document that expressly addressed the subject of legal standards of proof and the burden of proof, approximately 2 pages were dedicated specifically to the preponderance of evidence legal standard, 2 pages to clear and convincing standard, applying infrequently in very limited circumstances, and 1 page to beyond any reasonable doubt, a standard used only with filings made pursuant to the Adam Walsh Act, Protections and Safety Act 2006. As to the 2 pages covering the preponderance of evidence standard, they merely repeat the same USCIS policy manual material cited in this study, earlier in the study, the basic materials also include optional materials on standard proof. So they did training on standard proof isn't there. So it is, I guess, 100% important. That's the biggest takeaway from this recording so far, is to include a reminder of the standard of proof in pretty much all your petitions. I mean, if you're doing a really good I-130 where people have like, 6 kids together for a marriage case, yeah, you don't need this. But when you're doing L1, H1B on a nuanced like work topic, all this kind of stuff, add the preponderance of evidence standard, remind them of the adjudication standard, because there's a good chance they weren't paying attention when they're training. Adjudicators are not currently making use of all available USCIS systems before issuing RFE. This is interesting behind the scenes stuff. During this study, the CIS Ombudsman asked the USCIS whether adjudicators have the ability to access information about prior filings and outcomes as they're reviewing case submissions. For example, a search of USCIS's computer-linked application information management system claims 3 may inform an adjudicator that prior petitions filed with the same employer have been regularly approved or denied or even sent RFEs. Consideration of such information of record may be determinative in closed cases where an adjudicator is considering whether or not to issue an RFE. Responding to our inquiry, USCIS confirmed that adjudicators do have access to the system that provides such information, and further advised that they may also request and consider information found in prior petitioner cases to assist them in determining whether to approve a case or issue an RFE. The USCIS policy manual reminds adjudicators that before issuing an RFE, they have discretion to validate assertions or corroborate evidence and information by reviewing USCIS or other governmental files, systems, and databases, or by obtaining publicly available information that's readily accessible. So they go to Google. Exchanges with USCIS on this point inform the USCIS Ombudsman that the adjudicators do not routinely or nor proactively search for information, citing generally to the lack of adequate time to conduct such additional research. Which is important. They don't have time. And a lot of times clients like, oh, what if they research this? I'm like, yeah, they can research, they don't have time. Then again, some random officers for EB1A cases will go do their own research and try to find stuff out. That was just some information interesting behind the scenes information I thought I wanted to share. That was the end of that section. Next, they go into TPS, which I probably didn't make too much time on because I don't deal with TPS too often, so I wasn't really focused on it. But you can check it out in the Ombudsman's report if it's a case type that you handle. The next section, look back at USCIS unprecedented fiscal year 22 efforts used all employment-based visas. There's not much there other than like a chart that has that highlighted here. I mean, there's stuff there, but I don't deal with it too much. So, you got to take my biases here. But they have a chart that reminds you of the allotted visa category numbers. So like 40,000 go to EB1, 40,000 EB2, 40,000 EB3, almost 10,000 EB4, almost 10,000 EB5, for a total of 140,000 EB visas given out each year. I didn't make any notes on the other stuff. Plus, I'm like 80 pages into it. I think I was getting tired of reading this whole thing. So that may be a reason. Next is improving the customer experience from the contact center to the field. And they go into like the whole system about how communications are happening. One part I wrote notes here is to anyone other than a sworn off. Let me back it up. Where did I start? Section 1367 generally prohibits employees of DHS, DOS, DOJ from permitting the use or disclosure of any information related to a beneficiary of a pending approved application or petition. This goes into the fact that the headaches when it comes to if you have like a VAWA case and you want to contact USCIS about it, because of the statutory like privacy requirements that go with it, it becomes really hard for people that are VAWA or maybe even U visas to contact them about a case or get help. So it creates a really difficult situation for these people. And Ombudsman brings it up like, well, we got to help fix that situation. I've had that to happen before. For example, I had a change of address that I do for one of them, and it became a nightmare trying to change the address. So that was it. But an interesting thing is that at the end, on the appendices of the Ombudsman's report, they have a bunch of statistical charts and data. On a business side, like if you're watching the video of this right now, you're going to see I'm going to have a chart up where it has listed where all the questions come, the major areas where the ombudsman's received questions about issues, and different maps, both country map and a state of and a USA map. So on the USA map, like it shows 280 top 20 cities of U.S. case assistant requesters. Los Angeles 280, San Jose 374, Austin, Texas 215, Houston, Texas 418, Brooklyn, New York 463, New York. So on a business perspective, Miami 432, Chicago. This map highlights where the immigration business is, the major stuff. So if you're thinking about setting office and you want to do stuff, now I have people in real rural areas doing great, so take this with a grain of salt. But it really shows where the major, it's what's expected. California, Washington State, Northeast New York, and then Florida and Texas, Chicago. So, and Memphis, Tennessee. Tennessee is booming. So those are the major, I guess, markets for immigration. So something to look into when you're marketing, places to look at. And then on a national level, it was China, India, Iran, Nigeria, Brazil, Venezuela, Mexico, one or two countries more. But these are the main countries that have problems, which shows they're probably the main countries that have business and stuff going. And then when it comes to requests for case assistance for top office locations, Nebraska Service Center, this and that. But for field offices, it was versus Dallas, Chicago field office, Chicago field office, LA, and Houston. So these are cities. I'm in LA. Houston is a big office that deals with a lot. Most of my citizenship cases usually in Dallas. So Texas is big, and then Chicago. So these are big areas. If you're interested in focusing on any marketing niches, these are the ones. Thank you so much for listening. I do my best to not only help the legal stuff but business stuff as well. We're creating all sorts of meetings for the Immigration North Toolbox, expanding the system that we have for like, we have a monthly meeting for marriage immigration to talk about that. We have a monthly meeting for small solo offices who want to expand. We're going to be creating more of these. Currently, you have to pay per play for each one of these. But if I get enough mass of people, I'm going to make it where we have like a subscription system. We pay monthly, and every week you have access to an office hour mentoring session with an attorney for small business, for people that are law firms within larger non-immigration law firms, for people that have 1 to 3 associates who are making 500,000 or above, which 500,000 a million, for marriage immigration cases, for marketing purposes. So I'll make a subscription system. If you're interested, let me know. It'll be a couple $100 a month probably, but you'll make the money back because, well, everything you'll learn. My throat's burning out. So with that, I'll end the show in a weird, awkward position because I can't talk. All right, buddy. God bless. Be safe. Bye-bye.